In 1692, a court in Massachusetts hanged 19 people on evidence that nobody in the room could see. Not weapons, not stolen goods, dreams, sworn testimony about visions, accepted by judges and fatal. It began in winter, in the parsonage of Salem village. 2 girls, 9 and 11 years old, fell into fits, contortions, and screaming. A doctor found no physical cause and suggested the evil hand. Under pressure, the girls named 3 women. Then an enslaved woman named Tituba confessed in vivid detail, describing the devil, a book of names, a conspiracy of witches. 3 accusations became a hunt for a network, and the jails began to fill. In May, the new governor created a special court to try the accused under Chief Judge William Stoughton. That court made one decision that drove everything after it. It admitted spectral evidence, testimony that the invisible spirit of the accused, her spectre, had attacked the witness in dreams and visions. You could not cross-examine a vision. You could not produce an alibi because being asleep in your own bed was no answer. The court held that it was your spirit doing the attacking. The first to hang was Bridget Bishop, a tavern keeper in her 60s, tried on June 2nd and executed on June 10th at a rocky ledge outside town. 18 more followed by September. 14 women and 5 men in all, and the court built a trap inside the trap. Confess to witchcraft and name others, and you were kept alive to testify. Insist on your innocence, and you hanged. Not one person who confessed was executed. So people confessed and named names, and every new name fed the machine, manufacturing the very conspiracy the court feared. Giles Corey, a farmer of about 80, refused to play. He would not plead guilty or not guilty, so he could not be tried. The court's answer was to press him under stones for 2 to 3 days until he died. Tradition says his last words were more weight. George Burroughs, a former minister, recited the Lord's Prayer perfectly from the ladder, the one thing a witch supposedly could not do. The crowd wavered. Another minister on horseback steadied them. The hanging proceeded. Then the machine met the one thing it could not survive, an evidence ruling. In October, the influential minister Increase Mather declared it better that 10 suspected witches escape than that one innocent person be condemned. The governor dissolved the court. The replacement court could no longer rest convictions on spectral evidence, and with visions off the table, it convicted 3 people out of dozens. All 3 were reprieved. The rest were pardoned. Same accused, same colony. Remove one category of evidence, and the machine could not run. The unwinding took centuries. In 1697, on a public day of fasting, Judge Samuel Sewall stood in a Boston church while his confession of blame and shame was read aloud, the only trial judge to publicly repent. In 1711, the colony reversed 22 convictions and paid restitution to the families. More names were cleared in 1957 and more in 2001. But one name was missed every single time. Elizabeth Johnson, Jr., convicted in 1693, reprieved and then forgotten by every act that followed. Her conviction stood on the books until an 8th-grade civics class in Massachusetts petitioned the legislature to clear her. The state formally exonerated her in July of 2022. 329 years after her conviction, the Salem docket finally closed. Nobody convicted at Salem stands guilty today. What survives is the lesson the trials burned into American law. The right to confront your accuser exists because once, in a small Massachusetts town, the evidence was dreams, and you cannot cross-examine a dream. This has been Under Oath.